My name is Behnaz Mansouri, and I'm a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides low-cost representation and free advice and counsel to Washington State residents, to residents of Washington State who have been denied unemployment benefits or whose award of benefits is being challenged. We are here today with our weekly webinar, which occurs every Monday at noon. The purpose of today's webinar is to share the latest on unemployment benefits, to provide information about a recently filed lawsuit, and to answer your questions. We'll share commonly asked questions during the presentation, and I'll also be monitoring the questions in the chat today. I'd like to introduce our speakers from the Unemployment Law Project, Executive Director John Tierpak and Staff Attorney Ann Paxton. I'll now turn it over to Ann.
Thank you, Behnaz. So just to make things slightly different today, I thought we would start with the latest news because there has been quite a lot happening this week in the unemployment benefits world. And Washington State is one of the leading sources of news. So to start with, the Employment Security Department, the governor, in conjunction with the legislature, has extended the suspension of job search that's required in order to qualify for benefits until August 1st. So this has been, it was initially set for a month back in March, and it's been extended every few weeks by the legislature, sort of at the last minute. It was going to expire in July 1, and now it's been extended till August 1st. So the waiting week has also been suspended. That's the normal waiting time after you apply for benefits that you have to wait before you start receiving them. So that waiting week is covered by the federal, the CARES Act, and that has also been extended to August 1st. Another important piece of news at the federal level is that the Paycheck Protection Program of the CARES Act, which is a support program for small businesses that, in order to keep them, allow them to keep people on their payrolls. That deadline for applying for that loan, which is a totally forgivable loan, so it's essentially a grant. That deadline has now been extended to the 8th of August. The point is to provide a direct incentive for small businesses to keep their workers on the payroll. They started resuming applications acceptance July 6th. The point is to provide at least 8 weeks of cash flow for businesses through these 100% federally guaranteed loans. And the average loan size is about $100,000, but a lot of small businesses, especially if you're self-employed, you may also qualify for smaller amounts that will keep the payrolls alive. The unfortunate thing is a lot of things at this point are going to be expiring around the end of July, beginning of August. So it's, I think, important to remember to brace yourself for the impact of that program expiring, along with potentially the job search and waiting week. We can hope that will be again extended. We won't find out until the end of this month, though. The important thing that's expiring is the July 31, essentially July 26th expiration date of the Pandemic Unemployment Compensation Program, which is the added $600 per week, which has been going on to every person's unemployment benefit in the country. That is regular benefits as well as benefits under PUA, the federal program. So that's been an extremely significant infusion of cash into workers' pockets in order to sustain them through all the events that have been happening. And with the expiration of that looming, we can expect a lot of unsettled people and a lot of turmoil. There is a campaign underway now to try to get that $600 per week PUC extended. We can, and I just got this at the last minute, Benna, so I can get you more information about it, hopefully during the questions. But what they're trying to do is recruit national organizations to fight for an extension of this $600 per week to support state partners. And the program is called the Save the 600 campaign. And they are hoping, Congress is on recess until July 17th. So there is a small window of time here in which to get as many emails and messages to Congress in support of the $600. It's going to be a very important source of financial support, not only for businesses, but also for especially for workers. So right now we're not hearing encouraging signs from the Senate, which has said they're not going to pass an extension of this, but we're hoping that with the maximum pressure put on Congress, that it can be extended.
And I'm going and dropping the link into the chat right now for that Save the $600 campaign.
Oh, good. Do you have that? Do you have it? Good. Okay. Thank you. Next news that I wanted to mention is extended benefits up to 20 weeks becoming available. So this is a triggered program that has been around for decades, since the 70s, that called extended benefits, EB. So if you hear that, it's not part of the CARES Act, it's part of the standard regular benefits program. It has allowed people to receive benefits an extra 20 weeks. Normally that would put you at potentially 46 weeks, but with the added 13 weeks that we've already seen from the Emergency Pandemic Unemployment Compensation Program, PEUC, there's potentially an extension up to 59 weeks of unemployment. The downside of that is that the qualifications in order to receive the benefit become a lot more stringent. So right now, under a PUA and under regular benefits, you're allowed to turn down a job offer if it's not, quote, suitable work, which is defined as work that is in line with your qualifications, your experience, and your job history. What happens with extended benefits, and that kicks in after a certain level of unemployment, which we've far surpassed by now. What happens under that program is that suitable work becomes redefined as any job that you can physically do. So if you were offered a job and it is something that you're physically capable of doing, and even if it's not in your field, then you are expected to accept it, at least in terms of the requirements relating to your background and your qualifications, if you are physically able to do it. So that becomes the definition: if you have the skills and ability to do it, if the gross weekly pay is greater than your weekly benefit amount, and it pays at least the minimum wage in your area. So that still does not address the issue of worker safety. So that's a separate set of issues, but in terms of suitability of the work in comparison with your qualifications and experience, that's how it's defined. There is one escape clause, which is the working conditions are less favorable than similar work in your labor market. Under those conditions, you are also allowed to turn down the job, also if it requires you to join or to resign from a union. So next I wanted to mention progress on claims processing. There's a huge article in USA Today, which I highly recommend, came out just this morning. But I will first give you what the portrait is from Susan Levine, the commissioner of ESD. As you may remember, they had a program called Operation 100%, which was aimed at disposing of and addressing, resolving, disposing of all the outstanding claims within certain time frames. Well, those time frames have been progressively extending through the spring and summer. Where they are right now is they have people who have applied between March 8th and June 15th. They still have 34,555 people whose claims have not been resolved. So they're working on those, and they say that's their top priority. We don't know how, there's a lot of controversy over what that number actually includes, and we believe that it might be quite a bit higher because people have been finding that when they appeal an adverse decision, it is not going to the Office of Administrative Hearings in many cases. It's staying within the Employment Security Department and sort of finding someone who can look at it in terms of re-adjudicating it there, which means it's getting stalled. So there are a lot of asterisks to include when you're talking about Operation 100%, but they are reporting some progress in their claims processing. What the USA Today article reported is that nationwide, only 57% of unemployment applications have actually been paid. Now, again, in Washington State, as you know, because of the fraud, the massive fraud that's been program that's been perpetrated against the state and the public here, there are a lot of claims that have come in that are not legitimate, and sorting through those has been a major task on part of the ESD. So it's a little bit hard to pin down what do those numbers actually include. But according to the data that was just analyzed from the Labor Department from March 1st to May 15th, nationally 57% of unemployment applications have been paid. But in Washington, we've been one of the slowest. Only a third of claimants are receiving benefits according to this data, new data from the Department of Labor. And apparently USA Today contacted the Washington Employment Security Department, and they did not dispute that conclusion. So there is a big gap between what we're hearing about Operation 100% and what we're hearing about the number of claims and that have actually been paid. There are quite a few still outstanding. While all of that's happening, a new event has taken place, and that is something very unprecedented. The Department of Labor has asked all the states to turn over its jobless unemployment benefits data about all of its claimants. They subpoenaed every state for comprehensive unemployment insurance data on millions of claims filed since March, when the pandemic was officially declared. And of course, there's a lot of concern that this is going to further delay processing of claims. The subpoenas were issued June 19th. This was the first that I had heard of it. They gave the states until last Friday to submit the data. Some states have submitted a request for an extension and received it. I do not know yet whether Washington was one of those states, but the data was quite extensive. They asked for 26 different categories of information for each claim, such as bank account numbers and employer addresses, according to a copy of the subpoena that USA Today received. Maine did receive a 1-month extension. We're trying to find out if Washington has also gotten that. But as you can guess, this is probably going to affect further delay processing of claims. We discovered in searching data at the Office of Administrative Hearings that very few of the appeals that people have applied for when they've been turned down for benefits are actually arriving at the Office of Administrative Hearings in order for them to schedule a hearing date. This is very unusual. A year ago, there would be on the order of a couple thousand hearings every month relating to employment security. Starting in March, starting in April, the number of appeals that were referred to OAH started dropping. In April, it was about 1,400. In May, it dropped down to 550. And in June, it was 228. And we were trying to get a better explanation about this from the Employment Security Department. What they've told us is that they have diverted a lot of the appeal requests into adjudication process, which, as you know, is very, very slow already, to see if they can be redetermined in-house before they're sent on. This is sort of puzzling, really surprising, because we don't really see how that's a way of speeding processing of claims. It just adds more to the burden. So we'll have to see whether that, they have said that they are getting the process streamlined, so we'll have to see if that is starting to happen. But that is a real point of controversy right now. And just a couple other things to mention that have come up before we turn it over to questions today. One is we received a question about what to do if you have a mixture of W-2 income, maybe not a huge amount, but the majority of your income is from self-employment. What do you apply for? As you may remember, in order to receive benefits under PUA, the federal program, you have to be denied regular benefits. So first you have to go through that process. And ESD has said they're trying to smooth that out and streamline it so that it's a little bit more of it's a little bit less confusing for claimants. But so because of that requirement, in order to get your self-employment considered, you have to be denied regular benefits. Unfortunately, if you have 680 hours of W-2 income in Washington State, then you're likely to get, you'll have to apply for regular benefits, and you're likely to get approved, but it will be for a very small amount. You won't be allowed to, since you're receiving regular benefits, you won't be allowed to apply for benefits based on your self-employment income. If your hours were below 680 hours, however, under W-2 income, then you could qualify under PUA. So it's one of those kind of anomalies that has occurred. It means that a person with a majority of their income from self-employment, but just enough income from W-2 would not be able to qualify for the full amount that they would qualify under PUA. So that's been a concern for several people, because a lot of people do have a mixture of income, but that is, unfortunately, that's the answer we're getting from the Employment Security Department. And just to mention about an ongoing issue that is really awaiting a resolution that we don't have all the answers to yet, and that is worker safety. When people are offered a return to their job, whether it's because they've been on standby or they've been laid off, but their employers are ready to start hiring again for whatever the circumstances, and the workers are concerned about their safety in returning to the job. The Employment Security Department has been very clear that worker safety is a priority. They don't want people to have to return to unsafe jobs, but defining that safety issue is, it could be a problem, because ESD is asking claimants who have worker safety issues to be very specific about what it is they say the employers are failing to do. Just looking at the description from the Labor and Industries Department, there are several provisions that employers are asked to do, which is mandatory social distancing, sanitizing, frequent and adequate hand washing required, and training of employees. So if you, as an employee who's offered a job, can point to specific things that the employer is failing to do, that would shore up your case that there is a workplace safety issue. But ESD is going to be somewhat demanding about making a specific argument that the workplace is unsafe. I always like to include this eligibility checker, because it shows what the ways in which you can qualify for unemployment benefits because of the COVID pandemic, relating to whether your child's school has been closed temporarily, and you have to take care of the children, whether you were diagnosed with COVID or a family member was diagnosed. Are you showing symptoms? Have you asked for a diagnosis? That's another way. Are you at high risk? So there are a lot of ways in which workers can protect their health, but in terms of a specific employer, you will need to have very specific reasons why you're worried that is not a safe workplace. So I think John has some details. Maybe we can talk a little bit about the lawsuit, or anything else you want to add, John.
I'd like to add just a bit on this worker safety. There's been some public comments from ESD that fear of returning to work alone is not good reason. Well, it should be looked at a little more closely than that, because fear for many people is anxiety that is quite severe in terms of a medical condition, post-traumatic stress. There are many psychological and other medical conditions that can't be just sort of dismissed with saying fear alone is not enough. So if you or people you know, or people you are representing, if you're an attorney, say they're afraid to go back to work, try to look beyond that, just not as sort of a general concern, but there is often something much more serious behind it. We speak to a lot of victims of domestic violence with PTSD, a lot of combat veterans with PTSD, other people with medical issues. So fear can be a medical issue. As far as the court case in Olympia, just a little update. On June 5th, the Sheridan law firm in Seattle filed a petition for a writ of mandamus in the Washington State Supreme Court. And you can go to the Sheridan law firm's website if you want to read the court filings. And they did a motion to expedite or accelerate the case. So we expect the court to look at this sometime in the coming weeks. If you have any specific questions, you can put them in the chat or email me. I'm going to put my email in the chat. Also, if you know people who want to make a witness statement for the case, somebody who's been waiting for benefits, either from March, April, or maybe somebody who got benefits and who was cut off in May with the ID check and never came back, our office can contact the person, get a declaration from them that can be submitted with the case. Also, just in general, for whether you're an advocate or a person who's not getting any help with the unemployment, we are advising people contact the state senator and state representatives. I will put the website link in the chat to find your district. That has been effective for some people to have the representative or senator reach out to USD, and that has worked for some people in some cases.
Okay. Benaz, it looks like there's some of the questions might have to be deferred until for specific inquiry later. But are there any general questions we can address?
Certainly. Thanks, Ann. Yes, and for those questions that need a little more individualized attention, I'm going to be reaching out to you specifically with some contact information. John, there's a question from a participant who applied in March, received documents asking for a physician to fill out, as well as their employer. And they've been providing all this information, and they are interested in knowing if, okay, hold on one second. Sorry, the question moved. One moment. Okay. They have not received any benefits for 18 weeks. And is this information that would be helpful for the writ? Is this communication that would be helpful in a declaration or anything that could help with the writ and also help to process her claim faster?
Yes. When you do a declaration, or as I call them, a witness statement, you would kind of lay out your history with trying to get benefits and how it has impacted you, what your efforts were. So that would be helpful. I'm going to add my email to the chat, and the person can contact me directly or anyone else, because I think numbers are important. I think what ESD publicity or public relations department is doing is trying to put out that, well, we are getting close to solving this. You know, we are on our way. And yes, it's true, many people have had their claims processed, but the fact is we are still getting over 100 phone calls per day. So there are many thousands of claims that have not even been processed yet.
Great, John. And along those lines, we have a participant who is feeling that this may be a deliberate action taken against him. Is he being deliberately ignored? Because it has been since mid-May when he's applied for benefits. He received notice that he was approved, but now he's not received any payment. He's unable to call in and hasn't gotten any information or any benefits. Can you talk about whether this might be deliberate or if this is just sort of systemic at this point?
Well, I think when you have thousands and thousands of people who are denied, ESD even admits now how many thousands of people haven't been processed even yet, people from March. So as far as whether it's a deliberate thing, I would have no information on that. I think the system is so big and so overtaxed and poorly managed that I think it would be hard for them to come up with an intentional plan to blacklist someone, for example. But I don't know, individual. I know that each case has its own little problem, whether it was a glitch in the online application, a question that was answered a certain way, or whether it's a whether it's sort of a more of a technological glitch, or whether it's one question that wasn't asked a certain way. One of the problems we've seen over and over is that people who've put in information because of poorly worded questions and then have attempted to do a better explanation, and that's been ignored. Or people who were cut off due to the ID check in May, provided their ID, and are still waiting since May for their benefits to be restored. So I would urge you to contact your state senator and representatives to ask them to advocate in terms of getting your claim processed, but also you're welcome to contact the Unemployment Law Project if you want to make a statement for the court case.
Also, just a point that John's brought up several times before is that the ESD itself has said that it's trying to deal with 10 times the normal claim amount, and it has not staffed up at the same order. So if you're doubling or even tripling your staff, you're not going to get near to getting to tackling the backlog. So as much as they've been trying to say what their plans are, it's really, there's a point where there's a physical limitation to how much you can do with the same amount of staff, or not that much additional staff.
They really put a lot of reliance on the website, and I think it's thinking that people can get through, and they're not factoring in the human element, the fact that people do need to speak to someone in person to either explain things or like even make an application or to clarify something. And their staffing level increase has been pathetic. It's very small in terms of actual numbers of people hired. And the publicity stunts like bringing in National Guard, I find to be kind of a joke, because I love our National Guard. It's not them, I don't want to say that, but for a government agency with a solemn duty to provide benefits in a time of crisis, to months after the crisis begin, then call in volunteers for help, seems just a sign of incredibly poor management. Really, it's outrageous. They knew what the unemployment rate was going to be in March. They had ample opportunity. And I haven't seen any evidence that they actually tried to go to our legislature or governor for more money for hiring. I think it's just gross negligence.
I agree with that wholeheartedly, John. We have a question from a participant about the survey that Working Washington is conducting. And the question is, do the files that are sent get reviewed by ULP? And a subsequent question about, do we have any information about the investigations into fraud, and are they holding up the payments?
So John, do you have any information on the Working Washington survey?
Well, we've been working with Working Washington and Fair Work Center, and have been touching sharing information both on what's going on with the ESD and with the WRIT, and Fair Work Center is supporting the petition for the writ in the Supreme Court. So we have had contact, and that I believe people have been referred in terms of making statements for the writ, and the Fair Work Center, I believe, will be submitting their own supplemental materials for the court case. Oh, and what was the second one now?
In our investigations into fraud holding up payments.
Oh, yeah, I mean, just that this whole ridiculous cutoff that they did, where they penalized everyone over the crimes of a few, is still holding up. People I talked to just in the last days, I'm dealing with many of these calls myself, and I'm hearing people who have been cut off in May, who provided information, who provided their ID, are still waiting for their benefits to be restored. And while it's true that some people might have an ID issue, I talked to one man who had some of his ID, but he didn't have a passport, for example, and you know, was sort of putting together other information. But for every one of those, everyone, you know, there are dozens or more that I talked to who had all the required information and submitted it. And often more than once, I've talked to people who submitted it 3 or 4 times thinking that that would help. So this investigation is still causing problems. And it's been a big excuse for ESD to not to like hold up things. It's always been their go-to excuse. And I kind of look at it now as a blessing for the department to have this fraud scandal as a way to cover up their own poor management of the program.
We have actually talked with claimants who are on the phone, among the very few who reached an actual agent at ESD, and have had the agent tell them, yes, I can see that you've submitted your ID several times. It's right here on the screen, but the system isn't accepting it. So this is another example where there might be an over-reliance on IT as a solution to cutting back staff. If you can only cut back so far before your reliance on IT is going to come back and bite you, because there's some kind of glitch in the system and the vendor can't address it this month, and it won't be until 3 months later. And they still have not fixed this one thing where people are repeatedly submitting their ID and getting no acknowledgement. So there's just so many ways that the fraud issue is holding things up. It's hard to say where to start.
And it's even, I've talked to more than one person whose employer has intervened, that their former employer or their employer that they're kind of on leave from, the employer has intervened to attempt to verify their identity, that, you know, they've been working with me for 5 or 10 years, and that still hasn't worked, which is the most ridiculous thing I've heard. It's very strange that they have a system in which even when you do get through, the person isn't empowered to solve any problems.
Extremely frustrating. We have a great educational question. Can we explain the difference between adjudication, a hearing, and an appeal?
Okay, I'll start. John, maybe you can add.
I'll fill in.
Okay, so what happens when you submit a claim? You provide a lot of information to ESD, and then that information has to be verified by information from the employer, and also with their own systems. For example, if you submit a social security number that their system is telling it has already been had a claim filed and been paid, as has happened with some people in these fraud situations, then it's going to kick out that claim as well. So what happens is, if your claim does not have any discrepancies, social security number is the same, employer agrees the number of hours you worked, everything, the addresses are correct, and all of that, then it may sail through, and you might actually get paid within a couple of weeks. If there are any discrepancies, though, it goes to a process called adjudication. So that's where something has to be ironed out. They contact the employer, or they contact you to say, we found this, please clarify what's going on. Can you show what the real information is here? And adjudication can take quite a while, because the respondent has to have a time frame in which to answer. They may not get back in time. Then ESD is stuck deciding whether they're going to go ahead with the claim or wait until there's some response. We've had a lot of employers that are very negligent about responding. That can really bog down the process. So adjudication can go on for quite a long time, and especially under the current conditions. But under normal circumstances, and if your claim is stuck in adjudication, you don't have a decision, you don't have a determination. So you don't have an opportunity to appeal. If your claim is denied, then you can file an appeal. And that should be a separate process. Under normal circumstances, ESD would refer the appeal to the Office of Administrative Hearings with a packet of your information, your exhibits and your interviews with the adjudicator, or whatever information it has. Then Office of Administrative Hearings has been in the past fairly good about scheduling a hearing. They would send you a notice of hearing. In a couple of weeks, you would have a chance to tell your story before the judge. The employer would be able to attend as well. And that is called the hearing process. So adjudication is before the process of filing an appeal. Adjudication, then determination, then an appeal if you're denied, and then a hearing at the Office of Administrative Hearings. But there's been a lot of interruptions in the process, the normal process, because of COVID and a lot of other factors.
So under normal circumstances, if the issue is about why the job ended and they want to confirm with the employer in the adjudication process, it should only take a week or two to get through. And we've seen many decisions made where one or the other party hasn't responded, or if they did try to respond, it wasn't received, and they go ahead and make a decision based on what information they have, because they can't. Otherwise, an employer could block all unemployment claims by just not responding. So they usually give them some time, and they say, well, we've made this decision that benefits are be granted based on the information we have. The employer did not respond. Your reason for either quitting the job or the reason why you were let go is, qualifies you for benefits. The words appeal can mean different things at different times, and that's why I really like this question, because an appeal is sometimes used to refer to the request for a hearing, which it is. It's that first level of appeal. But an appeal can also be appeals beyond it, because if you lose at the hearing, you could file a petition to the Commissioner's Review Office, which would review the case and make another decision. And then it can be appealed beyond that to a Superior Court, Court of Appeals, and so on. That's, of course, rarely done, beyond that level. So an appeal, when someone calls our office, this is always the question. Somebody calls our office and says, I have an appeal. We ask many questions just to figure out which level of appeal they might be at, because these words are used interchangeably. Like recently, the words furlough and standby and layoff are used interchangeably, but may have different meanings in a certain context. So it's a good question. And I've even talked to people when I've gotten them on the phone to say, well, where are you at in the process? And they said, I talked to a judge, and I'm assuming they had a hearing, but they were actually talking to a person from ESD who was just gathering information about the case. So it can be confusing, but right now, the important thing for all people is, if you're in a confusing situation or know someone confusing situation, is to try to figure out what level it is, and then to contact our office for help.
Great, John. And one thing I always like to let claimants know is to make sure you read every letter and communication you receive from ESD. Read them very thoroughly. They're utterly confusing. They provide conflicting information. They're extremely droll and boring. I understand this fully. However, there's often a nugget of information in there. Either they're asking you for information that's missing that you need to provide, and if you don't read that part and don't provide it, they'll use that as a reason to deny your claim or stop your benefits. There's also the information about your appeal rights and the ways to go about filing appeal. This information is often hidden, and it's difficult to suss out. So we really recommend that you go through all of the letters very carefully and thoroughly. John, we have a participant who is a middle manager, has been on standby for the past 12 weeks, has been receiving UI benefits throughout this time. Hoping to return to work soon, the organization is undergoing some restructuring. And the question is, if the employer calls them back to a lesser level position or a lesser paying job, if they refuse the position, will they lose their unemployment benefits?
It's possible, and it's a case-by-case basis that should be looked at very carefully. And I'll give some general information that I think will be useful for everyone, is that there's sometimes a question of, can you do something and get unemployment? And then there's another question sometimes of whether that's a good idea or not? Because, for example, we know we're in a severe economic turndown. And maybe if the economy was zooming and, and your field particularly too, that's another question. What is your field? Is that field in demand? Are there jobs out there? Can you just go out and get another job? Versus are you in a very specialized field that's very, very hard to get hired? So if the job is substantially less favorable or unsuitable or unsafe, that would be a good reason to turn down, like a pay cut that was substantial, a demotion, a change in location, a change in duties. That may be reason to turn it down and get benefits. It's risky because different people have different opinions on how close is close enough. And that's always been an issue we've seen in hearings. But the other part I think that's more important to think about is, what does this really mean for you and your future? Because I try to think like what I would do, for example, as a legal services attorney. As a legal services attorney, there's very few places I would really want to work or go to. And so I could say, well, okay, so they're asking me back part-time, it's lesser, my titles change. That may be a good move for me to keep that job or to accept that, knowing that when things get better, I'll get my old pay back, or I would be connected in the field that I love rather than be in a job market and just be kind of out there trying to find something. And of course, with my experience, for example, many law firms wouldn't hire someone with my experience as not being suitable, in terms of my work and knowledge and experience. So sometimes people do take a step back before stepping forward, because what I've always been thinking about over the years working with unemployment cases is that unemployment, even with extensions, is temporary. And I've talked to some people at the very end of a claim, at a period when there's no extensions, who say to me, should I take this job? And I'll say, well, you've been looking for 5 months and your unemployment's going to run out next month, and you're unhappy that the best offer you've gotten pays a little bit less than you got, which, again, nobody likes to work for less, but the person in that position might want to think hard about whether it's a good idea to accept a lesser job knowing that their benefits will be running out. And this year, because of the politics involved with extensions and with job search requirements, and we don't know if the job search requirement is going to be extended, or the suspension of the job search requirements, whether that's going to be extended or not. We don't know how many extensions will come up with benefits. It is risky, and these are very hard personal questions. But it's important to think carefully whatever you do, because it may well be something that might work well for you would not work well for someone else.
Just one note of caution there. It's a very difficult decision to make, to decide, is this job up to my qualifications and experience? But as much as you can, it's better to stay in the same field if you possibly can, because if you are in a position where you actually have run out of benefits because the requirement is for you to accept any job for which that you're physically able to do, or because you don't have benefits, maybe you give up on your job search and you say, well, I'm just going to get a job as a barista or working in a hotel. Unfortunately, the way the system is set up right now, that changes your customary occupation, because your customary occupation is the last job that you've had. It is not what you've been doing for the last 10 or 15 years if you've had the same line of work. So it's just something to keep in mind, because I've had many cases that we've seen where the person is trying to make the case that they were looking for a job as a dental assistant, but they had to take a job as a cleaner. And the decision was that's what they were. They're a cleaner now. And in fact, in many cases, that means that they had to accept jobs that might be have graveyard shift, because the typical shift is a 24/7 the typical hours are 24/7. So there are a lot of intricacies here, but if you have the chance to stay in the same field, you might think about that.
Great, thank you both. We have a question about ESD and how they're prioritizing claims. Do we know if ESD is prioritizing by individuals or per household? So if there is a household with 3 to 4 unemployed individuals, does the household get priority, or is it just on a case-by-case, claim-by-claim basis? Do we have any info?
No, and it's just such a random, with all the calls we receive, it just seems so random of who's denied and who's not, who's granted. I've talked to many people whose coworkers are in the exact same position, have gotten their benefits, exact same job, exact same job separation, and they don't, but their friends are at work, their coworkers have. Prioritizing, I think it's random, and that the problems that come up are just triggered by things, whether it's an ID check or something about the way a question was answered, or just technical things in getting through a claim. It is something that, again, I encourage people, if they are still waiting, to contact their state senator and representatives.
And don't forget contacting the press. Michelle Lee at King 5 or Get Jesse, Paul Roberts at the Seattle Times. They're always looking for stories, and your story would be interesting to them.
Great. The governor's been telling us to stay home for months. Did ESD expect us to continue working during the months we were told to stay home because it's healthier to stay home?
Well, I mean, some people can work from home. I think the big issue for everyone is safety and health. And so I've talked to many people who have been able to work from home or get new jobs working from home, depending on the profession, but many jobs can't be done remotely. And so that really puts people who have skills and experience only in, would be in-person work, like restaurant or healthcare, things like that, where in-person contact is essential. And again, things should be viewed on a case-by-case basis in terms of what's safe, but no one should be forced to return to an unsafe work environment. And it may be unsafe due to the employer's failure to follow guidelines, but it may be unsafe for an individual or their family members. Even if guidelines are followed, the risk due to specific health issues may be so great that even an employer that's really doing everything possible, that still would not be a safe work environment.
Thank you, John. Looks like we have one last question in the Q&A box. Now that we are in a new quarter, might someone who has been on PUA now be eligible for UI with a new benefit year? Does ESD automatically look at that?
Well, that's a pretty technical question from, as far as my bailiwick. I wouldn't expect that ESD would automatically look at something like that if it involves switching gears to the regular UI program. I don't know. John, have you heard anything about this?
No, it's a good question, but it's sort of beyond like what I've been thinking about or been looking at. I do know that when a person opens a claim, it affects what base year they use for the hours, or whether hours qualify, and it sort of complicates it by so many factors now, because normally under normal conditions you would look at that base year or the alternate base year and see, okay, are there enough hours or not, the person would be denied. But now with the pandemic unemployment, even if a person doesn't fit that, they may be eligible for the pandemic. So it's quite complicated, but my view, I always go back to some just general ideas, which is, when in doubt, apply. If you're denied, consider appealing it maybe. And then what I've heard over and over is if you're denied regular unemployment, then file for the pandemic programs.
Right.
Great, thank you. That's all the questions. Anyone have any other questions before we wrap up?
Before we wrap up, I would like to just add one more thing about whether the person should accept a job. And this came to me after I answered the question, which is in terms of looking at a person's career future, it's sort of a well-known idea out there that you're more likely to be hired for a new job if you're currently working. That just seems to be the way it goes. And some human resources offices won't even look at people who are unemployed. So over the years, when I've talked to people who've been unfortunately given an offer of let's say a lesser pay or lesser position, for some of those folks, they have told me that it was a good idea to accept that job, knowing that they're just going to get out of it as quickly as possible, just as a career bridge, not to have a sort of a blank period on their resume. So like those are other factors too, in terms of whether it's worthwhile to be employed even at a lesser pay, because with the $600 a week going away, even if it's lesser pay, it's probably going to be more than the unemployment claim. Again, I can't speak to an individual on it, but it's very complicated. And actually earning money, paying taxes, getting hours for a potential new unemployment claim in the future may be a good thing, career-wise or economically a better thing, because that part-time job may turn into a full-time job quickly as well, or allow you to get hired somewhere else. And I think that for some people, getting sort of kicked back a little bit on the pay has been an incentive to move up and move out.
Great advice, John. Just for your information, my email and John's email are in the chat box. If you have any additional questions that haven't been addressed here, feel free to reach out to us directly. Thank you for joining us this week. We look forward to seeing you next week. Thanks, everyone. Bye-bye.
Thank you.